finish it. Again, the homework's gonna go up here. Again, you're gonna see this for a while. But you know what that means? You better know it. You better really know it. Does that make sense? That's mandatory homework. Reading is mandatory homework. Without it, you will fail this class. That is how simple it is. You don't read. I am a supplement to textbook. I'm not writing the law, I explain it. And if you don't have that foundation, it's really hard to do well. That's why we have the textbook. It is, accessed in your dashboard. Please take advantage of it. Great thing with the way it's set up. You have interactive things that can help you. You have like glossary words. Just take advantage of all of your given resources to help you in this class, but most particularly yourself with the reading of the textbook and take notes on it. Okay, so chapter 2 really remember when you talked about the difference between civil law and criminal law? Okay, remember, we're not dealing with criminal, we're dealing with civil wrongful actions, which are failure to perform or breaches, as we call them, of a private interest. Okay, so we talked about the party who's been wronged is, remember, any legal entity that has the ability to sue is referred to as the plaintiff. Remember that? And anybody who has the legal entity to be sued is referred to as the defendant in a civil lawsuit. And remember, parties represent, can be individuals. It's going to be easy because we're going to understand it that way to get you going. But it can be a partnership, it can be a group of people, it can be a corporation, it can be a city, municipality, it can even be a sovereignty or a government. But the bottom line is you have to have the legal capacity to sue or be sued. Got it? So civil actions, we got a plaintiff and a defendant. And we've learned, I think we jumped in very slowly as to there's certain foundational requirements that have to be satisfied when a plaintiff is filing a lawsuit, okay? You can't just, wouldn't that be nice if you just don't like someone, so you just want to file a lawsuit and say, hey, I want to make sure that they don't have enough resources or they're not even located in the area that I'm suing, so I'm going to slam a lawsuit on them and they're going to have to pay a bunch of money to say they didn't do it. They probably won't, so I'm going to win. That's not how it works. Certain foundational requirements have to be established in order for a plaintiff to actually say, this is what I'm complaining of, okay? So let's take it real slow, and we're gonna just take a look at, okay, I'm gonna draw, I'm not an artist, but this is gonna be the face of the first legal document that a plaintiff, the party that claims that they were wrong, files in a civil lawsuit is called the complaint. Think about what the word means, it's pretty simple. They're complaining, right? They're complaining, it's called a complaint. And typically, the face of a complaint, you're gonna see the plaintiff here versus the defendant. Everyone clear? And if you have an attorney, the attorney's name's going here, everything off the plaintiff, and the attorney's name as well as the defendant. Everyone clear? So you just have that. And right here is where I want you to focus your attention to. Okay. When I say COA, this represents cause of action. Okay, that's what they're called, causes of action. And again, the pi sign plaintiff, remember that? And the delta sign is defendant. Okay? So when we take a look at a complaint, we have the plaintiff complaining, and what they do is they list all the causes of actions that they have arising out of a single incident against that defendant in the complaint. But this area is for those causes of action, okay? So, for example, simple car accident case. If you are suing someone in a car accident case, particularly, we're gonna learn about all of these torts, it's a negligence action, okay? So you had a negligent action against a particular defendant, you'd write the word negligence here, okay? Let's say you also want to sue him because there was negligence, but there was also a battery that occurred. Whatever it is. And if there's an accident and you're suing that defendant as a plaintiff, all of the claims against that defendant have to be put together in the same action. You don't want to sue, like you have car accident, let's just call it X. Car accident X. don't want the plaintiff saying, I'm gonna sue the defendant for negligence in this complaint, battery for this complaint, do you see what I'm saying? Arising from the same action. That's a waste of the court time, and it's not gonna work. You have to like streamline all of your actions arising out of an incident that you're suing, and you put it into one complaint. It's arising out of the same transaction. You don't wanna waste people's time. Everything that's happening against that defendant, put it in one complaint. Everyone clear? Got it? So if we have these causes of action within the complaint, there's a list. So the first cause of action is negligence. So we're gonna learn all about what we call, we need to establish what the elements, these are just legal terms, elements of negligence are, okay? We're gonna learn it, and I'm not testing you on this now, I'm just giving you an example. You have to show that there was a duty of care owed from to the defendant to the plaintiff, that it was breached, and there's proximate causation leading to what we call harm, okay? But the bottom line is, those legal elements need to be specifically mentioned in some way, shape, or form within, under the cause of action. You say, the plaintiff breached their, the defendant breached their duty of care to this plaintiff, and you explain what's going on. But all of the elements have to be there. Then let's say the second cause of action, which is, say it's battery, and then you have to list all the elements for the battery. Do you see how this works? So in a complaint, when you have a plaintiff that is suing a defendant in civil court, when you have your complaint, it's very challenging for someone to actually litigate. I mean, it depends on how smart you are as far as your study, but if you want to represent yourself, a lot of times what happens is someone will put down that negligence occurred. And let's say it really did occur. Let's say the defendant actually committed negligence against the plaintiff, but they don't know how to legally explain it. Do you understand that? They may not have, that plaintiff may not be able to articulate the legal elements that satisfies the cause of action of negligence. And what happens is when the court takes a look at that, they'll dismiss it. Does that make sense? And they're not gonna tell you why. You're gonna go, I thought I had a good case. But you can't just say, oh, this person ran into me. Do you see what I'm saying? You gotta break down and hit all the legal terms. There is a duty of care owed. What is that standard? Do you see what I'm saying? So that is why people hire lawyers. Just trying to break this down for you, okay? So within this is your basic complaint, and when the complainant alleges all of the causes of action, okay, then they put their case on first. If you have an attorney, it's, the plaintiff's attorney puts on their case first. And they have to satisfy something called burden of proof. And the best way to explain it so you can visually understand it is in civil court, the basic standard for a burden of proof is what the plaintiffs have to establish. Basically, the plaintiffs have to say, we believe that we brought forth enough evidence with the witness testimony, whatever evidence you want to bring to court, to claim that these causes of action happened. Here's the standard of what we call the burden of proof. You have to establish that it's likely that it could happen, what we call over the preponderance of the evidence. Like, what the heck does that mean? It's just more than 50%. It seems simple, but it's challenging. So the burden of proof is the plaintiffs have to simply establish, typically depending, it's a general standard. There's higher standards, but generally that the particular cause of action, possibly the defendant had committed those causes of action more than 50%. Does that make sense? So if you think you know the scales of justice, okay, if you put a feather on one side, that's more than 50%. You understand that? That's the standard you have to show to claim to the court. And again, if you don't have a jury, we also told you, like I told you last week, that in a civil case, you may not have a jury because you don't want to pay for it. Everyone clear? Bottom line. And contract actions, it's a snooze fest. If it's a breach of contract, you want to get a jury to talk about papers. Does that make sense? Very challenging. So a lot of cases that I used to litigate was just, we called it a bench trial. I liked it, quick and easy. Well, they're not easy, but they're not quick. Why did I even say that? But the bottom line is, nothing. And it's funny, because you always go, I need that brief, and it's never briefed, kind of funny how well it works that way. But it's called bench trial, is you're just going in front of a judge.
Okay, there's no jury. There's a lot of cases that just are bench trials, okay, especially in civil court. However, whatever the standard is, if I'm the plaintiff's lawyer, if I'm showing the bench, which is the judge, I have to show my plaintiff's lawyer what I'm claiming in my complaint, those causes of action occurred more than 50%. Everyone clear? Makes sense? And when the court will say, you've satisfied your burden. Once they do that, now, flip it over, let's hand the defendant's attorney. It's the defense case to now claim all of the stuff that they're telling you is a bunch of BS. Do you see what I mean? They're then putting on evidence to show that these causes of action are not true. Everyone clear? They're gonna put holes in the credibility of the case the plaintiff built. And now we have, it's your call. Everyone clear? It's the judge's call. It's the jury's call. That is how a case works. Everyone clear? Kind of starting to see that? Yes or no? Remember, what's the worst thing that can happen to you in a civil action? You gotta pay money, right? You're not losing your freedom, but it's still bad and it could be a lot of money. But this is what happens, okay? This is how it's litigated. I just wanted you to get that kind of in your head so that we can step into the foundational requirements. Here we go. Before the court, when I say the court, whether it's a jury trial or a bench trial, it doesn't matter. Before the court even takes a look at the causes of action. Everyone clear? Before they do anything, the plaintiff who's filing a lawsuit has to meet they have to show that there's certain foundational requirements that even allow the plaintiff to be in that particular courtroom. Are you hearing what I'm saying? So there's certain foundational requirements that have to be established so that the court even has the authority to make a ruling over the particular matter. Everyone clear? So that's where I'm going to, and that's where we jumped into. I think we briefly got into standing to sue, correct? So now we're going to get into all those foundational requirements. I'm going to pause. Any questions so far? No? Okay. So let's take a look. Okay, these are plaintiff's requirements for a lawsuit. The first is, I got standing to sue. What does standing to sue mean? Let's go back and jump into it. Remember, that plaintiff has to show that that plaintiff was directly harmed, that if there was a contract, they were in the center of it, if there was some sort of impending threat, it was present, it was imminent, it was towards that plaintiff. The bottom line is, you have to show plaintiff that you suffered some direct personal harm, and that harm comes in one of three forms: physical, financial, or emotional, and it affected you, and you were wronged in some way. You were injured in some way. You were harmed in some way. Somebody did something wrong to you in some way. The word harm doesn't just mean it can be financial loss. Do you see what I'm saying? It can be a physical loss. It can be an emotional hurt. It can be deemed an injury. There's a lot of synonymous terms in law that really throw students, because we're like, well, is that a wrong or is that injury? Doesn't matter, it's the same. Do you see what I'm getting at? So I want you to be able to digest the vocabulary. It's so important so that you're not thrown in application. Everyone clear? I'm going to continuously feed you a lot of different terms that can be used to explain something. So when a plaintiff files a lawsuit, there's a reason why they're in court. They were harmed. Everyone clear? And that harm was direct. Remember, we learned it cannot be based on what we call a mere hypothetical situation. Something that's not ripe yet. True? Something that hasn't happened yet. Why? Because it didn't happen to them. It's not there. Also, what you should know, here we go, this is new now, is it cannot be based, your harm plaintiff cannot be based on what we call a mere academic interest, okay? What does that mean? Well, there's a lot of things that happen in life, and we know, like, depending on your moral framework, what you're made of, we know things are wrong, okay? And even if you believe you fit the category where, I just think that's so wrong, I want to jump in and be a plaintiff in this lawsuit. Simply put, it can't do it, it didn't happen to you, okay? So, for example, I'm just gonna bring up a lot of cases, like just general things that have happened in the world that I think we all know. I'm going back to, there was a lawsuit over 20 years ago, but it's such a basic case. African-American gentleman went into a Denny's, server was white, and flat out said, "We don't serve your kind," refused to give him service based on the color of his skin. Okay, public establishment, we know that this is what? Wrong. You guys think it's right, it's crazy, okay? It's absolutely wrong. Got it? So, hypothetically, this is, again, I'm creating a fact pattern. This is not what happened in case I'm teaching you something. Everyone clear? So just know, giving you a really basic example so you can apply. So the gentleman goes home, he's married to an African-American woman, and they have 4 kids. Everyone clear? If the family wanted to sue Denny's for discrimination, do they have standing to sue? The answer would be no. The only person that does is the gentleman. Does that make sense? Do you see what I'm saying? You can't, no matter how much you're affected by a particular situation, even if you're connected through, do you see what I'm saying? You're connected to it. You can't just jump in and say, oh, that could happen to me because I fit that category. Well, it didn't happen to you, so get over it. Everyone clear? So what I'm saying is the only party that has the ability, or what we call standing to sue, is who? The guy that it happened to. Everyone clear? Yes or no?
Yes.
Okay, well that's it. Is that too, that is not difficult, standing to sue. So let's go back. What is standing to sue? It is that first foundational requirement that every plaintiff needs in order to instigate a lawsuit, which means they have to show in some way the plaintiff was directly harmed or personally impacted, affected if it was a controversy, if there was some sort of eminent threat, it was directed presently at that particular plaintiff, and that harm comes in one of 3 forms: financial, or physical, or emotional. You need one of those 3. Remember, it cannot be based on a mere hypothetical situation, and it cannot be based on what we call a pure academic exclusive interest. Does that make sense? Okay, we're done with that concept. Any questions? Are you feeling a little better as how this class is run? I hope so. Always know I will, after I finish the concept, I'll always ask you questions. But always remember, do not change that hypothetical. Make sense? Okay, next up. We're gonna learn something called jurisdiction. Okay. This is a huge term, and it's depth, okay? And it's a big concept, and we break it down. Okay, and also, just so you know, if any of you are Latin freaks, that's what law is based on, it's like English language, so it may help you. Okay, like for example, I have a Juris Doctorate. Where does that end? I have a doctorate in what? Juris is law, okay? So when you look at the words, juris is law, true? Yes or no?
Yes.
Jurisprudence, and then diction is to speak, okay? So that term is a big term. We wanna also make sure that the plaintiff has standing to sue, that the court has some sort of authority to speak the law over the defendant. I'm just, again, let's just have you absorb what I'm saying. What you gotta do as a plaintiff, it would be very unfair, even if you were harmed, for example, if you wanted to sue a defendant and the defendant lived in Tennessee. Does that make sense? And what you're suing, where that defendant has absolutely no connection to this court, to Long Beach, does that make sense? Or even California for that matter. If there's no connection, that court doesn't have any authority to speak the law over that defendant. You have to have some sort of connectivity where it attaches that, for example, when I took the California bar, every state has a different bar exam, okay? So I was authorized to practice law in the state of California. I didn't pass the Tennessee bar. Everyone clear? Every state, if you're gonna practice as an attorney in different states, you have to take the bar exam to be able to have the authority to speak and litigate the law in that particular state. Just like the laws in the state of California are different than the laws in Tennessee. Does that make sense? State laws can be very varied. As a result, there has to be some connectivity for that court to have the power to speak the law over the defendant. Does that make sense? Okay, well, hold on to that thought. And there are automatic ways in which that particular court has the power to speak the law over the defendant. We're gonna get into the ways that you can attach what we call jurisdiction over the defendant because it's essential. Everyone clear? So again, we're not even looking at the complaint yet. You see what I'm getting at? We're just trying to make sure we're in the right place. Got it? So we're gonna have to go to the first area. It's called personal jurisdiction. Okay. In order for the plaintiff to be able to litigate in the court of their choice, you have to make sure, number one, plaintiff, you have standing to sue, check, right? Number two, does this court that I'm suing in, does that court have the power to speak the law? In other words, let's make it easier, keep going there, jurisdiction over the defendant. Well, it automatically does if you can establish that the court has personal, Latin is called in personam, personal or in personam jurisdiction over that defendant. Here's the easiest thing to know. How do you figure that out when you're a student or anybody else for that matter? You gotta say, did the cause of action as to why the lawsuit occurred, did the cause of action happen in the area where the plaintiff is filing the lawsuit? Or does the defendant reside within the territory? Okay, two ways. Automatic personal jurisdiction. Did the cause of action happen in the area where the plaintiff filed the lawsuit, or does the defendant reside within that territory? Remember, when you're suing a defendant, it's not about your rights, plaintiff, sorry. Nothing's about your rights, because you're not, someone's on the hot seat, the defendant. Their rights are the rights that will always be preserved and protected, because you are innocent till proven otherwise. Does that make sense? Yes or no? So, we gotta take a look at that. So, I'm gonna give you a baby case out. This is the easiest way to learn jurisdiction things. We're doing a baby car accident case, okay? So here's my hypothetical. Because you're all gonna be the plaintiffs, remember that, okay? So you are all, for this hypothetical, residents of Long Beach. Got it? Keeping it easy. But you decide you wanna visit friends in Texas. Take a road trip. As you're driving through Arizona, you get into a major car accident, right? You believe that the other car was speeding and went through a red light and hit you. Your car is not drivable, it's totaled, pretty much. You have some personal injuries. You're not dead, but you've got some broken ribs, and things aren't great, okay? First of all, you're not gonna go visit your friends in Texas. You're gonna go to the hospital back in Long Beach. Everyone clear? The car that hits you, the person driving it, is a resident of Michigan. Everyone clear? They're just driving through Arizona. They live in Michigan, okay? They claim, what? I didn't go through the red light. Think about this major car accident case. I had the grin. I made it through. Everyone, okay, there's gonna be a little major argument here. So, defendants reside where, folks? Michigan. Plaintiff, Long Beach, California. Accident occurs where? Arizona. Make sense? Everyone clear with that? Okay, so you get back to Long Beach. Long Beach Memorial Hospital, those bills are steep, you know, if you don't have a car. So you sue. You're suing the particular defendant. Typical car accident case is the tort of negligence, okay? You sue for negligence, that's your cause of action. And of course, you're the plaintiff. Where do you want to sue? Here in Ocean Boulevard, Long Beach Courthouse, Superior Court, just in case you probably, hopefully never, you guys never have been there. That's great. Never mind. I don't know, hopefully it's not criminal. criminal. But anyway, you go into the Long Beach courthouse, okay? You wanna file your lawsuit there. Let's just go through this. Do you have standing to sue? Of course you do. You can identify this easy. You have physical injury plus financial. Does that make sense? Okay, done. You see that? Easy peasy. Okay. Now the question is, does the Long Beach court have jurisdiction over this Michigan defendant? Do you see what I'm getting at? Well, let's take a look. Do we have personal jurisdiction? Well, personal jurisdiction, did the cause of action happen in this area that you're suing? No. Do the defendants reside within this area? Does the Long Beach court have jurisdiction over the defendant under personal jurisdiction? Yes or no?
No.
No. And you're thinking, I started seeing how this works. Do you see what I'm saying? Don't you think this would be pretty crappy if you were the defendant and you didn't do it? And you're stuck for Michigan to litigate a case in California? Do you see why there's requirements? You can't just zap a lawsuit on someone. There's a lot of what we call chess moves before you actually look at a complaint. That's another reason why in civil court, an attorney is probably necessary. I'm not saying you can't do it, folks, but does that make sense? So, all right, you don't have personal jurisdiction. You're like, well, I need to sue this person. I got over $25,000 in damage to my car, about 15 grand in medical bills, and no. Are you kidding me? I'm missing work? So, what do I do? Well, of course you can sue them. Where do you have personal jurisdiction in order to sue them? Well, Arizona. Does that make sense? You can sue this defendant in Arizona because Arizona has personal jurisdiction over the defendant because the cause of action happened there. Does that make sense? You could also sue them in Michigan, but why would you give them the advantage? Do you see what I'm saying? Because why? They reside in Michigan. Does this make sense? Yes or no?
Yes.
Okay. Is that hard? Okay. Is that a bummer? It is. But what if I don't want to sue in Arizona? I don't blame you. I wouldn't either. I definitely, if I'm the attorney, I wouldn't pursue it. I'll figure it out. Okay? Is there a way to figure this out? Maybe. Okay? We're going to talk about it. Something called the long arm statute. Got to prove what we call minimum contacts. Okay. This can be a way to get personal jurisdiction. Great. When we talk about a statute, just think it's law, okay? Because I don't need to get the nitty gritty between all of the stuff, federal. Okay, it is a federal law. The long arm statute, and it's funny that I say this, but I'm a visual learner. I'm so demonstrative. I have to write things down to absorb it. Some people are auditory. I try to do both, you know what I mean? But I don't know. Long arm is like, think of this. You're the plaintiff. This is silly that I'm saying this, but I know this will work for you. You're sitting in Long Beach, and you want to file that lawsuit against that defendant in Michigan, right? So, using the long arm statute, I'm in Long Beach. Can I take my arm, my long arm, and go to Michigan and grab that defendant and force them to defend this action in Long Beach? Just think about that. How can I force this? Well, this statute allows you as a plaintiff to bring to the Long Beach court's attention however few, or hopefully however many contacts that out-of-state defendant has with this territory, okay? And obviously, it's gonna be unrelated to the car accident. It's gonna be unrelated to the car accident because there's no car accident happening here. So you have to put kind of what I call, do a little research, be a little detective. You gotta figure out, is there any reason why that Michigan defendant is generally in Southern California? Do they come here for vacation? Do they do business here? Do they stop here, go to Hawaii? I don't know, figure it out. Does that make sense? Do they have family here? Do they have a condo here? I don't know. You're gonna have to do the dirty work and figure out however few or however many connectivities or contacts that out-of-state defendant has with the area that you're suing in. okay? Hey, I don't want you don't have to be the court and make a decision, you just have to understand this concept. Bring whatever contacts you can ascertain to the Long Beach court's attention, right? And let them decide. If they believe that being in Long Beach twice a year is good enough, great, you know what I mean? It's not your call, you're just gonna make a creative argument saying, well, this is what I found. Hey, I've made calls before where one contact was sufficient, does that make sense? Don't ask me, you bring the best you can and you argue, because it will be so much more helpful to your client, does that make sense? So, worst case scenario, you're in Arizona, got it? So go for it, it's worth the time and effort to figure this out, got it? So, do a little bit of research and bring whatever context you may find to the court's attention. Again, is it business? I mean, do they target and do even like, what we call, like business sales through the internet in this area where they're exchanging product or sending products here? There's so many different types of connectivity. What do we have? Bring that to the court's attention, and please don't ask me, how do you find this all out? Because that's not the point of this. Does that make sense? This is where I'm preempting the crazy, okay? I'm just talking to you about how to get there. You wanna figure it all out, you'll learn, a lot more. Everyone clear? But I'm just trying to get you to understand the concept of jurisdiction. Got it? So if you do that, under the long arm statute, it gives you, plaintiff, the authority to bring to the court's attention whatever context you may ascertain that out-of-area defendant has with the area you're suing in. If the court determines that those contacts are what we call sufficient minimum contacts, you've established personal jurisdiction this way. Does that make sense? Okay, any questions? Eli, is that right?
Yeah.
Okay.
Could it be the whole state of California or just the city of Long Beach for the minimum contacts?
We're just gonna do Southern California, but I'm not gonna quiz you on
Well, no,
more
like-
expanded law. I'm not gonna answer that right now. I'm just talking about the territory of Long Beach. Does that make sense?
Sure.
Because, again, you have to understand the layers of law that I'm not explaining to you. So, I'm just getting you informed about the concept of jurisdiction. I want you to know there's gotta be some sort of connectivity with this area. And that's how I'm gonna test you. Everyone clear? Make sense? But I appreciate, again, please, I love that he's asking that question, because you don't know. Everyone clear? See how that works? And I enjoy that you're interested. Any other questions? All right, now let's change the party that hit you. We're still in Arizona, okay? So, you're gonna think this is a sick joke, because I give plenty of them. But let's say the person that hit you wasn't a Michigan defendant. They were driving a Peterbilt, big old truck, and they work for Coca-Cola. You know what that means? Sorry. I see dollar signs. You guys are looking at me like, what? Hey, you know the big joke with lawyers, when you get in a car accident, I'm like, what car hit you? I'm not taking the rundown Fiat, you know what I'm saying? Bentley, I'm in, never mind. Okay? Hey, you can't get money if there's no money to get. You understand what I'm saying, people? You guys are looking at me like I'm sick. This is true. If you got hurt, well, you'd rather be hurt with the same injuries with a Coca-Cola truck that hit you than some random person. Do you understand what I'm getting at? Yes or no?
Yes.
Okay. Don't think I'm sick. I'm being real, okay? So, bottom line, the Coca-Cola truck hits you in Arizona. Here's a different with a defendant who's a corporate defendant. If you're a corporate defendant and you place your products into the stream of commerce in any of the 50 states, okay, you automatically have sufficient minimum contacts as a plaintiff to sue in Long Beach, okay? Coca-Cola is not just a national company, they sell their products globally. Does that make sense? As a result, no matter where you want to sue, you can sue. Everyone clear? So even if Coca-Cola's headquarters, let's say, are in Boston, Massachusetts, you don't have to go to Arizona or Boston, Massachusetts to sue Coca-Cola. You can sue them in Long Beach, because you can automatically establish that personal jurisdiction through the minimum contact situation because of them placing their products into the stream of commerce. And when I say those terms, I'm not suggesting that you even have to make a penny off of the sale. But if you are putting your products into the stream of commerce in any area, whether someone actually buys a product or not doesn't matter. It qualifies as someone who's a corporate defendant who can be right to be sued in that particular area through the legal context. Does that make sense?
Maybe you'll ask a question, sir.
Isaac? Is it Isaac?
Yes, you always ask for questions, but I forgot. So,
I'll ask for you if you have a question.
This might be getting into what you said, where it's like study law, you don't worry about it, like, say I post something on like,
Did you, no, we're not changing a hypothetical,
Okay, copy.
create your own. So with my hypothetical, does it make sense?
yes,
Excellent. Do you see why you can't change? Because you don't know the area of law you're gonna enter into. That's why you always say you're not gonna change my hypothetical, but you always try to. Does that make sense? And that's okay. But I'm gonna say, no, you can't do that. Any questions so far? Okay, let's continue. So, let's just go back to just the basic accident with a regular person. I'm just trying to teach you all the areas. So, you got hurt, and yes, easy to identify. You've established standing to sue because you have physical as well as financial injuries, and you want that Long Beach court to have the power to speak the law, which is jurisdiction over the defendant, and you don't have personal jurisdiction because the cause of action did not happen within that territory, nor is the defendant a resident of a particular area. Everyone clear? Okay, and it's not a corporate defendant anymore. Is there another way to establish jurisdiction over the defendant? Answer is yes, but not with this fact pattern, so I'm gonna change it, okay? If you are a plaintiff and you're suing a defendant based on a property deal, and there was a dispute over property, and you filed a lawsuit where the property is located, it doesn't matter what's going on, you can automatically establish personal jurisdiction through what is referred to as in rem or property jurisdiction. So let's say that you're buying a house in Idaho, everyone clear? And you're from Long Beach. I don't care, the defendants can be from Maine, buyers and sellers of a home in Idaho. And there's a dispute over escrow fees or whatever regarding that sale of that home. If you as a plaintiff file your lawsuit in Idaho, doesn't matter what's going on, you've automatically established what we call in rem or property jurisdiction over the defendant, and you're right to start suing in that location. Does that make sense? Yes or no? Excellent. That's not our accident case, but if you have a property dispute, that can work. Let's continue. All right, so if we have no cause of action in Long Beach, accident didn't happen there, defendant resides in Michigan, and it's not a corporate defendant, we don't have personal jurisdiction in this territory, we have no way to use the long arm statute to establish sufficient minimum context, it's not a property case, so we don't have in rem or property jurisdiction, so our best bet would be Arizona. Does that make sense? Again, you could do it in Michigan, maybe you have relatives there and that works for you, I don't know, but the bottom line is, that's how it works. All right, we're gonna move to another requirement, but before I do, any questions? In your name, Sarah?
Can you explain?
Is it Sarah?
Yeah.
I'm just totally guessing off the,
Yeah. Can you explain again the property jurisdiction?
I sure will. Okay, she just wants to know is property, you need a big booming voice, Sarah. But, no. You can hear me 5 rooms down, trust me. Property jurisdiction is literally real property, like a house, or it could be some sort of land, whatever, it's not a car. Car is not real property, okay, so I should make that distinction. A car is personal property. Personal property is movable, you know, it's like, real property is whatever's, it's a structure that is attached to land or land itself. Does Does that make sense? So if you were buying land or a home somewhere, not a mobile home, but does that make sense? And there was a dispute regarding that particular property, and you want to sue the defendants regarding that particular property, you can file your lawsuit in that area where the property is located to automatically establish personal jurisdiction in this way. But you're gonna just call it jurisdiction, and how do you get that? It's called through the property jurisdiction, that's all. Does that make sense? Anything else? Well, let's keep going through these requirements, shall we? Okay, I'm gonna pause. I'm gonna assume that is Emily. I'm thinking, just because you're in front, I see you always nodding your head with me. I'm gonna go on a leap with you. You read the chapter, or at least a little bit.
Yes.
Okay. Is what I'm saying make what the reading is much simpler?
Yes, it
Okay, I'm just saying this because I'm keeping it real. You want that to connect. Does that make sense? And trust me when I tell you, foundational learning comes with you figuring out nonfiction for yourself before I explain it. Because you have a base to go through. Everyone understand that. So many students will always challenge me, don't know why you do this. And you try to just get lecture first and then read it. But Emily's gonna kick your butt on that exam because she already has a base, she now is explaining it, and she's gonna make less errors because the test is timed. Do you understand what I'm saying? It is it's just a simple philosophy for investing in your learning, and there's a reason why it's tried and tested to be truthful. Read, especially, I'm talking nonfiction. You gotta read nonfiction constantly. That's what the homework is. Does that make sense? And then listen to lecture. Integrate it with your notes. Okay? I'm not the textbook, as you know. I make it in a fashionable, in a story. I try to apply it with things that can help you understand a textbook which teaches in a Socratic method. I learned the Socratic method, which I never understood what that was all about because in law school, I literally had to read the cases, and they wouldn't really, we dissect them, but then they never told us how to, they never gave me all the story. Does that make sense? Now, I got tested, and I would get it wrong, and that's how I knew the story. I didn't like that, but let me tell you something, that old method, forcing me to figure everything out myself, really got me to learn the material, because I would read it completely differently. Does that make sense? I would read it, and I urge you, if you can solidly get an A in this class, but more importantly, pick up your disciplinary skills when it comes to investing in your learning and success. And whatever you do, if you just first time go around, do what I'm telling you to do, you're gonna see a market change in your grades. You're gonna see a benefit to you in how you approach tasks and projects in business. And I'm truly a professor that's all about overall student success, okay? I have 2 kids. Trust me when I tell you this, I clean up my own house. I make sure that they're very successful. They're my guinea pigs for all of you, and they're very successful because it works. Like, no, you're not fooling around. Sit down and do that. And you're not going past go. Does that make sense? And this is like in 3rd grade. You got a science project, read it out loud, because I don't my son is use books for frisbees, you know, literally. He does fine now, but he's just no attention to reading. And I said, you are not going out to skateboard or do whatever you want to do until you read that one paragraph out loud to me. And it's just like tortured by me, you know? Reads it, I ask him 3 questions, he can't answer them right, I go, not going anywhere, do it again. See what I'm saying? Ask him 3 different questions on the same paragraph. You see what I'm getting at? Until you can do the what, when, where, and why, and be a reporter of each paragraph that you are reading, you don't get it. You understand what I'm saying? Comprehensive learning, that's what it takes. There is no shortcut, so don't ask me for one. Everyone clear? I'm giving you the tools for success. You want to improve yourself as far as your reading comprehension, which is super important, is the only way to get more seamless and more retention with what you're reading, especially nonfiction reading, is if you start slow. And constantly ask yourself, because at the end of the semester, if you keep doing that, it's just proof, I'm not the great scientist that does this, but you will improve your reading comprehension by a minimum of 20%. Okay? And you're gonna start to see, like, I read very, I didn't realize I do, I read very complicated material quickly, but I started very slowly. You see what I'm saying? Because it's just constant feeding your brain of how to, in context, look at things. And it makes you a strong problem solver, and that's really in business what you need. Does that make sense? We need a lot of people who know how to figure things out. We don't need robots, because we have plenty of those being created to take over your job. So you know what? Be a thinker so they can't take your job. You see what I'm getting at? It's so important. Okay, make yourself indispensable in a business. That's so important, and I keep trying to get you guys to understand that, and I hit it constantly, okay? So, here's some basic requirements, but we're still going. So, let's say the accident did happen in Long Beach. Okay, just make it easy. So we have personal jurisdiction in Long Beach, right? Okay. So now, we have another requirement. What am I on top of? Okay. Think where we are. Let's say the accident happened in Long Beach. Even if the defense submission, it doesn't matter. You have standing suit because you got hurt. Car's totaled. The court has jurisdiction to speak the law over the defendant because the cause of action happened here, right? Now we're going from like big picture, we're getting more focused, okay? Think about this. This is why, again, it's challenging to do without an attorney. You also have to make sure you file your complaint, think of it this way, in the right courtroom. Here's why. There's a lot of cases, pretty much all my cases, were in the general subject matter jurisdiction area. I don't even, have I had any in limited? I don't think so. You gotta know where you want your complaint to go. And no one's gonna tell you if you screw up. So pretty much most general, which is civil and criminal matters, are referred to as general subject matters. What is the subject matter? Is what you're filing your lawsuit about, okay? So you got your negligence, your medical malpractice, your defamation cases, your murders. They're all, even though you don't do criminal, these are just general cases. So how do you know where to, in your complaint, fill out the form? Does that make sense? To have it land in the right area? You just have to know if you're in a case that's more limited or specialized. Super easy, okay? This is the kind of law I don't do. And when people ask me, I'll refer you to an attorney that does that. I don't do bankruptcy law. I don't do probate law. I don't do family law. I don't do the areas, that tax law. I don't do that, okay? There's different courts that only can make rulings on those particular items because they're specialized in it. You just can't, you can't just do all of that. When you practice law, you pick a special, you know what I'm saying? It's like you don't go to a podiatrist for your heart problem. Everyone clear? They're both doctors, but you're not gonna get fixed. Everyone clear? So same thing with law, and same thing with courtrooms. They have jurisdiction over certain subject matters. So the key is, I don't know if you've ever heard of probate. One of my closest friends does probate, and it's so funny because when we first, this is like, I can't even believe it just seems like something out of a dream when I think about my rap here. It's just so funny because we both work for a big firm when we first started, and I had no idea. They just literally put me in litigation because I do have a big mouth. I get it, you know what I mean? And I'm a talker, other lawyers know your personality. I can be a lawyer and tell them if you're a litigator or not. A litigator is someone who's A, not shy, B, not shy, wants to speak, and is very opinionated and super stubborn, and you're looking at her. Does that make sense? I resemble that remark. That's true. This is where opposites attract. My friend, she's like literally one of my best friends. She's like so reserved, so soft-spoken, you know, she doesn't wanna talk in front of a crowd. Does that make sense? Probate is dealing with like dead people and what the people they leave, like their estates to. I call that boredom, okay? However, she writes wills and trusts. I know it's very important, people. I just would be bored out of my flipping mind doing something like that. But there's a practice for everybody. Everyone clear? And believe me, what made it was the joke was on me. She was out with the golf course with her clients. I was in the library till 2 in the morning doing research. Do you see the difference? I'm like, what's, you know, huh? She goes, where are you? I'm like, don't even start with me. I can't. Anyway, bottom line, those are limited subject matters. Do you see what I'm saying? It's called probate. And then family law is a law that, I don't even know the laws in family law. Everyone clear? It's a whole different gambit. And with custody cases and all, I don't know any of that. So that's also specialized. And then you have your bankruptcy. Don't know any of that. Tax, don't know. Do you see what I'm saying? It's just everyone has different fields for different things. So think about this. So you have standing to sue, you're filing a lawsuit. Long Beach Court has jurisdiction over the defendant, but whoops, you happen to check the wrong box. Does that make sense? And your negligence action ended up in a limited subject matter courtroom. For example, it ended up in a family courtroom. They're gonna just look at this and throw it out. You see what I mean? They're not gonna tell you, oh, you checked the wrong box. And if you're handling the case yourself, or you have a really stupid attorney, they're not gonna tell you the truth, okay? They just won't, because they're not gonna say, well, I guess we don't have a case. You see what I'm saying? And that's what you're gonna think. But there's just so many little technicalities to make sure you're gonna open the complaint and start. Everyone understand that? Any questions? Okay. You're gonna be happy. The last foundational requirement is venue. Okay. Have you ever heard this term before?
Yes.
You have? Okay, good. I think it's brought up a lot in a lot of cases, and it's super important. Location, location, location. It's maybe the reason you met your loved one. It's maybe why your real estate is worth more than somebody else's. It's maybe why your business gets better foot traffic. Because of the location. Does that make sense? It's also very necessary in a court of law. Because, hear me out. Let's say that you do have standing to sue, plaintiff. Let's say the court does have jurisdiction over the defendant because either the cause of action happened in that area or the defendant resides in the area. You have jurisdiction over the defendant. Okay. Let's also say that you filed your complaint in the right courtroom, so it has you have jurisdiction over the subject matter. Everyone clear? It still may be thrown out to a complete different location after all that, based on a venue opposition. Okay? What does that mean? Well, again, in this country, you're innocent until you're proven guilty. And venue's all about the location of where the trial is. Depending on who the defendant is, okay, and the publicity surrounding the case, it may be very unfair for that particular defendant to receive an equitable or fair trial if people have already made their mind up about guilt or innocence. You can't get a jury one way or the other. Does that make sense? Or there's just too much talk about what's gone on in the case. Bottom line, there could be many, many things that go wrong as far as giving that defendant an opportunity where you have jurors that aren't going to be fair. Does that make sense? Because they may have thought one way or the other. I'm going to take it to a criminal case real quickly just to give you the magnitude of it, because a lot of civil ones you're not going to understand, but it's the same situation. We're going to go back to Timothy McVeigh, the Oklahoma bomber, that scumbag, okay? Oklahoma bomber, as the name suggests, he killed a lot of people in the state of Oklahoma. He blew up the courthouse, there's some kids that got injured in the nursery, it was awful, okay? And I know that you guys heard these terms, because they're true terms, I mean, they're like lingos. When, in that case, it's like, have you ever heard the term dead man walking? Some of you, I'm so glad 3 of you are alive in this class, but yes, the term comes because it's so difficult to get a pool of people to be fair, even the judges to be fair in the location where jurisdiction's proper. Do you see what I'm getting at? I'm just trying to connect here. Even though people lost, this is criminal, but it's the same with civil, okay? Even though people lost their lives in Oklahoma, and yes, they abstained to sue in Oklahoma, does that make sense? It occurred in Oklahoma, so you have cause of action, does that make sense, the jurisdiction? And obviously, the subject matter is there, it's all there. He was not going to receive a fair trial in the state of Oklahoma. He was what we call a dead man walking, they want him out, they want death penalty, everyone clear? But lawyers litigated, and in order to have your right to a fair and speedy trial by the Fifth Amendment, the Sixth Amendment, according to the fact that all of the circumstances around that case would have led to him already being guilty. Does that make sense? And pretty much everyone in the nation, whether he lived in Oklahoma or not, thought he was guilty. But where they had the case tried was actually in the state of Michigan where he was from. Does that make sense? Because they thought that would probably be the most equitable. I don't know if you're ever gonna get a fair trial given those sort of extreme circumstances, but it was definitely not gonna be in Oklahoma. Does this make sense? Even though standing to sue in jurisdiction was proper. Got it? Think about that. My favorite Laker, it's not LeBron, trust me, it's Kobe. God rest his soul. Favorite Laker ever. Okay, love everything about Kobe Bryant and his work ethic as a basketball player. He's just dynamic. I know that everyone has their own opinion. Fabulous, love him, okay? But, love him as a basketball player, but you know, he had some marital issues. Remember what happened when Vanessa got the 10-carat rock? I'm sorry, honey, I didn't mean to screw around on you. You guys remember that? Eagle Rock, what is it, Colorado? There was a civil suit filed because some girl in Eagle Rock said that she was assaulted and battered by Kobe. She switched it from rape to something else. Okay? Now, if you were the plaintiff's attorney, you want it in Eagle Rock because everyone knows everybody. It's like a town of 5 people. Does that make sense? Obviously, everyone that wanted Kobe to play wanted him back in LA. You understand that? I don't really care what happened, I need you to play. I need another ring of people, okay? But in this case, it was moved. No. Name, sir? Chris.
So you know how we switched from Oklahoma to Michigan on the bombing one?
Yes.
If the states have different laws, do they still have to follow the Oklahoma law?
You don't have to worry about that. That was criminal, and but you don't have to worry about that. It's over the scope, but I appreciate that. Especially, I'm just trying to teach you to understand these foundational concepts. What does venue mean? That every defendant has a right to a fair and speedy trial, and if there's adverse publicity that can change a bench or jury's mind to go a certain way, and if you're not gonna get a fair trial, you have the opportunity to move it to more what we call probative or fair location. That's what I would mean again, probative. Does that make sense? How are we doing? Good. Is it Jeremiah?
Yes.
Okay.
On venue,
Mhm.
this might be over the scope,
It's
but
okay.
with the Oklahoma City bomber, let's say that.
No,
he
are you
was-
changing the facts?
I know.
No, then I can't entertain it, so I'm gonna stop you. So
I'm just curious about how venue works if
I-
everything happens
I
at one
don't,
location.
just, as long as you know, venue, just keep the facts as I gave them to you. Does that make sense? Name, sir?
Julia,
Gentlemen.
so if you're opposing the venue,
venue,
Mhm.
it's still, you only have the option to move into a place where you still have the jurisdiction,
No,
right?
I didn't say that. No,
Oh,
the
no,
court can
okay.
do whatever, no, the court can go to where they believe is the most fair location.
Okay.
Does that make sense?
Yeah,
You can ask for something, but the court's gonna put you where they believe is the most fair. Does
okay.
that make sense?
Yeah.
Okay.
So venue is just the location of the court case?
It's not just, it's, every defendant has a right to a fair and speedy trial, and you wanna make sure that they have equitable opportunity to defend their case, and you don't want adverse publicity surrounding that, so you don't wanna make sure that the people in the area already have decided the fate of that defendant. And as a result, you wanna contest the venue, location where the trial is, even though everything else may be established. Does that make sense?
Okay.
It's, I can't just say, you know what I mean, I'm like, and bring it back to comprehensive learning. Name, Sarah, you're Sarah and she's Sarah, okay.
So as a lawyer, you have the right to contest the venue, but the court is ultimately the one who decides.
Absolutely. Would that be nice if it was my way or the highway? I would love that.
And what is it, a fair and what trial? Or a venue? Fair and speedy trial? Sorry.
That's okay. Are you starting to see how there's a lot of behind the scenes? We haven't even looked at the complaint. We haven't even looked at the types of courts, but that's what we're gonna do now. Everyone clear? Are we good with these foundational issues? Great, let's move on to something new and different. For those of you that have read, it's probably, I'm covering a page and a half right there. Does that make sense? That's what I'm talking about. You are not gonna be able to connect with the material, and that's why that read's gonna be up there. And when I switch to a different chapter, I just go. Does that make sense? And you're gonna go, oh, well, let's just do one little chapter, I'll catch up. And then you get your, I don't know, predicting 60 on the first test. And then you're gonna drop, because you're like, you're gonna drop, I don't know, that great. You know what I'm gonna tell you? This monkey has to get off your back someday. You're a business student, pony up, get it right the first time. Does that make sense? It is a required course as a business student, and I find that most business students are afraid to take this class. And it's the one class that is essential, not just in business. I have nursing students taking this, you know what I mean? It is a class that people take because it's stuff they gotta know. And I find it really odd that business students on the whole don't wanna take it. Okay, I'm finally having to take the class because I'm required to, when I'm scared of it. Don't be scared of it. Embrace it. Knowledge is power. Does that make sense? Get fired up, because when you, I hope that most students take this as their first business class along with something else. Because it sets the tone on every other thing that you do as far as learning, okay? Don't be afraid. And honestly, the language, you're like, it seems difficult. It's only gonna be difficult if you keep saying it's difficult. Read it and then connect it with lecture. It's not. And I genuinely encourage all of you, if you please are still having trouble learning and I didn't answer a question in class, or you felt like you need more supplemental help with something, come see me during office hours. Everyone clear? I have office hours today, 2:30 to 3:30. Please do. And I'm gonna do a little promo, because before I move to the new area, I wanna encourage you, we are gonna start Business Up, and it is a dynamic opportunity for people to take leadership positions and get involved with potential networking. It's fabulous. Our business club, SC and UCLA contacted me, and they modeled their stuff after us. Because we set the tone, we do so many things. Students have gotten jobs with Google, Vans. I mean, it is just one of those particular clubs that builds on leadership skills. And a lot of students don't have the opportunity to have something because they're a student, or they're working at a job, which is still great. Maybe it's a server, because I did that all my life when I was in school, right? I think everyone should be a server at some point in their life. You're gonna learn, how to think quickly about money, do you agree? And how to be in the industry where zip your lip. Everyone clear? But bottom line, there's a lot of students that just need more skill set. Does that make sense? And we do a lot of activities up into our culmination, which is Aim for Success. We have about 250 people, and other schools, their students want to come to our event. We bring in really incredible speakers. We've had Olympians, we've had like Fortune 500 business execs. The good news is, you know that song, Friends in High Places, well, I got them, thank God. And between my personal connections, which is, it's blown away. Like, you know the college commissioner, Kevin Warren, you know, first black commissioner for football, he brought UCLA and SC into, you know what I'm talking about? You guys know what goes on in the world? Well, it's big news, Kevin Warren, he's literally one of my absolute best friends from law school. Went to law school at Notre Dame. We're like, it's just so funny. I mean, these are people that are like up there. I just call Kevin, what's going on? Like, it's so funny. I'm like, good move. Bringing the Pac-10, making it bigger, you know? So, do you see what I'm getting at? I'm not trying to be a name dropper. It's literally, I was at his wedding. I mean, this is funny to me. But the bottom line is this, it's such a unique opportunity for our students to be exposed, but I'm not forcing you all of this. Everyone clear? I say this because last semester it was such an epic fail, I didn't do it. I'm like, I'm not gonna start and be a chairperson of a club if there's not enough interest. And I'm like, you have no idea what we bring to the table, but I find it kind of crazy when students are like, I just don't feel like doing that. I have lunch. I'll go eat lunch because I'm not there. Because it is a unique opportunity. I've got Cal State Long Beach wanting me to do it for them. You know what I mean? I'm like, I don't teach there. I don't anymore, I used to. Does that make sense? So I share with you this out of not frustration, but a little bit from last semester, because it's almost like you don't know what's good for you, but you should take advantage of the opportunities that the business department has for their students, because we are acknowledged in all of the nation as the #1 transfer community college for business in all of the nation. And that's pretty incredible, and that's a great honor, okay? We've gotten awards from the White House. This is, I mean, it's kind of funny because we're like, that's our little department, you know? So it's kind of cool. It's very cool, and it's great because we have a lot of dynamic professors, and please know this, I'm selling you professors because they want to be here because of the quality of life, but their resumes are impeccable. Does that make sense? And most people pick teaching at a junior college, not because they have to, but because they want to. Because for me, I don't want to publish and work at a big university, which I've got offers to work for. I don't want to spend my time having a teacher's assistant teach you while I'm publishing research papers for the college. Does that make sense? I call that boring. Everyone clear? I want to be the instructor. And so do the other professors that are, you're very privileged if you take these certain, some great teachers. And I really wish, this is, my son goes to San Diego State, I wish he came here instead of go there. And I would tell you the track to go and make it work. Does that make sense? So take advantage of it, please. You will be very fortunate. We're gonna start that up after the 20th because I'll see who's in this class. We're waiting until after consensus. And then we'll get actively involved. We're gonna get, there's places, because usually when people are on the board, they're there for a couple of years. So we're starting from scratch. So this is a beautiful opportunity for any of you that want to take the helm. We've got presidents open, VP, I mean, these are big positions. And you work directly with the presidents of other colleges. It's student run, okay? There are qualifications. It is competitive too, which I like, okay? I'll bring more information, just get the kind of, it meets on Tuesdays from 12 to 1. And if you're on the board, we'll have meetings and we'll figure that out. Typically it's Thursdays 12 to 1, okay? But it's not all the time. Everyone clear? We do activities, but if you're on the board, you gotta just, obviously we've got the internet working. Does that make sense? There's ways to facilitate and have things work seamlessly. So keep that in the back of your head, more information about that after the 20th of February, just because I'll know who's in the class. And again, my co-advisor is Professor Cagnaro. Him and I share an office, but it's just, I might as well just, I'm not gonna do any new shows, sorry, to time. He was my student, he just ages me so much, I can't even believe it. Nick was in my class, literally, he sat in the front row many years ago, like, he was 19. Like, he was literally my student in my class, and he wanted to be a history professor, and I said, you will not be a history professor. I go, why do you want to be a history professor? I go, so you can memorize and tell people stuff that they can just memorize and read. And no knock on the history professors, I feel really bad that I say this, but I teach business and it's all about financial success. Does that make sense? Truly. And so I said, you did really well in my class, but you're super quiet. I thought he was really quiet. I'm like, speak up, you know? Got A's. And then he took Law 19, Class 60. I used to teach management, leadership management too, but now I just do all the law classes. I used to do mix of business management and the law classes. But he literally transferred to SC, went to his students invited me, I went to the graduation and I was like, aren't you happy not to be a history professor? Got a great job, made a ton of money working, he went through Costco, through their administration, got a really great deal, but it was so funny. He came down, he goes, I just want to teach. I go, no you don't. I go, you know, he goes, I've done all that stuff, but I really want to give back. Does that make sense? And he really wanted to trade financial success, and I shouldn't say this, it devalues for more of a quality of life success. Does that make sense? Because he started a family, he just wanted more quality time, but he still wanted to enjoy what he was doing. We got him in, and now he's a full-time professor. He teaches all the new stuff that he learned from the Annenberg School of Business, which is all the digital, social media, all that stuff. Really fabulous, you should take him. But he's my co-advisor, and I love that we work together because he brings me into the 21st century. Do you see what I'm saying? He's like, oh God, you're still doing that? There you go. You know what I mean? So I'm learning a lot of technology with everything, but you guys will have such a great duo at your service to help you as you grow through the semester and whatever's coming up. So think about that. There's more to come on that. But what I want you to do for Thursday is just continue reading. We're going to get into just a little overview, the differences between state and federal court, because there's a huge difference between the two. Now, a lot of students don't understand that it is a whole different jurisdictional situation. And in a car accident case like the one I mentioned, can you file in state court or can you file in federal? And how do you get into that? And what is the process that a complaint goes through in state court all the way up, and I'm going to talk about to the Supreme Court. And I'm also going to do the same in a federal court system and give you the differences of your choosing as to why you could go to either one to litigate your case. And then we're going to wrap it up. We'll finish chapter 2 on Thursday. We're then going to talk about ADR, which is alternative dispute resolution. Up to now, we're talking all about litigation when you file a lawsuit. But the better choice is to avoid paying the costs and fees of a lawsuit and try to resolve your case through less expensive methods. So alternative dispute resolution, we're going to test, I'm going to test. There's a lot of methods, but I'm only going to test on 3, which is arbitration, mediation, and then obviously we're going to talk litigation. Everyone clear? And that is for Thursday. If you can late, you can see me, otherwise have a better.